The Fifth Circuit has just made a major move in a critical Second Amendment case. The court has officially withdrawn its earlier decision that stated suppressors are not considered arms and therefore aren't protected under the Second Amendment. This reversal follows a significant change in position from the Department of Justice under the Trump administration, which now agrees that suppressors do qualify as protected arms under the Constitution. This development could have major implications for ongoing and future legal challenges to the National Firearms Act, NFA, especially regarding suppressor regulations. The case at the center of this is United States v. Peterson, where the constitutionality of applying the NFA to suppressors was being directly challenged. Mr. Peterson was previously convicted for violating the NFA. He argued that the law, as it relates to suppressors, is unconstitutional because it infringes on Second Amendment rights. Originally, a three-judge panel from the Fifth Circuit ruled that suppressors were not arms under the Constitution. Based on that conclusion, they claimed that restrictions on them didn't violate the Second Amendment. But now that very same panel has withdrawn its opinion, a rare and important step. Why the reversal? Because the Trump-era DOJ, through former Florida Attorney General Pam Bondi, filed a new brief stating that suppressors are arms under the Second Amendment and cannot be entirely banned by either federal or state governments. However, the DOJ also argues that the NFA doesn't constitute a full ban. Rather, it imposes regulations that, in their view, still align with the Second Amendment. In that same brief, the DOJ also urged the Fifth Circuit to reconsider its prior position, particularly the statement that suppressors are not protected arms, and correct that conclusion. In response, the three-judge panel withdrew its prior decision. This strongly suggests that the court may be preparing to rehear the case or issue a new ruling based on the updated arguments submitted by the DOJ. To understand how we got here, let's quickly review what happened in Peterson's case. In 2022, a joint task force of federal and state law enforcement, including ATF agents, executed a warrant at Mr. Peterson's Louisiana home. Peterson also operated a gun store on the same property under a federal firearms license, FFL. The warrant stemmed from alleged violations related to his business, including claims of straw purchases, improper record-keeping, and certain firearms sold through his store being traced to criminal activity. However, what ultimately led to his charges under the NFA was the possession of a single unregistered solvent trap, which authorities treated as an unregistered suppressor. That possession triggered the NFA violation charge. Peterson's legal team responded by filing a motion to dismiss the charge, arguing that the restriction violated his Second Amendment rights. When that motion was denied by the lower court, they appealed the decision to the Fifth Circuit, setting the stage for the events now unfolding. A three-judge panel from the Fifth Circuit initially reviewed Mr. Peterson's case and ultimately sided with the ATF and the Biden administration at that time. In their decision, the panel noted that this was the first time the Fifth Circuit had addressed whether suppressors qualify as arms under the Second Amendment. They further stated that, to their knowledge, every other court that had considered the question had reached the same conclusion, that suppressors are not protected arms. To support their reasoning, the judges examined whether a suppressor could be classified as a weapon of offense, a tool of defense, or something capable of casting or striking. They concluded that suppressors do not meet any of those definitions. According to the panel, Peterson had argued that suppressors are essential components of firearms and should therefore be protected. But the court rejected that view, stating that a suppressor on its own is not a weapon and has no significant value for self-defense. Unless thrown, a suppressor cannot strike or cast, they said. The court also maintained that suppressors are not necessary for a firearm to function. Based on these conclusions, the panel upheld the lower court's ruling and maintained Peterson's conviction. Following that ruling, Peterson and his legal team filed a petition asking the Fifth Circuit for a rehearing en banc, which means a review by all of the judges on the circuit, rather than just the original panel. Initially, the Department of Justice, still influenced by holdover attorneys from the Biden administration, opposed this request. They argued that suppressors are not arms, and that the case did not merit further review. However, when the Trump administration took over the handling of this case, the DOJ's position changed dramatically. In a newly submitted brief, the DOJ argued that the Second Amendment does, in fact, protect firearm components and accessories, including suppressors. Therefore, any restrictions on suppressor ownership burden the right to keep and bear arms. The DOJ stated that a ban on suppressors would be unconstitutional. At the same time, the DOJ maintained that the NFA's requirements, such as registration and taxation, do not amount to a ban and are consistent with the nation's historical tradition, particularly because suppressors have the potential to be misused. For that reason, they said Peterson's conviction should still be upheld. However, they acknowledged that the panel's earlier statement, claiming suppressors are not protected arms, was incorrect. Instead of asking for a full en-banc rehearing, the DOJ suggested that the three-judge panel simply correct its analysis and issue a revised opinion. Shortly afterward, the Fifth Circuit issued a formal notice announcing that the original opinion in the suppressor case had been withdrawn. This means the previous decision, the one that found suppressors were not protected, is no longer valid. What does this mean? There are a few possibilities. One is that the panel is clearing the way for a potential full court review. However, that seems unlikely, because the court's notice did not mention an en banc rehearing, something that would typically be documented if the full court were taking up the case. More likely, based on the DOJ's recommendation, the original three-judge panel has chosen to reconsider the case on its own, taking into account the new arguments and positions submitted by the Trump administration. If that's the case, we could be looking at a new opinion from the same panel, one that recognizes suppressors as protected arms under the Second Amendment. Since both Mr. Peterson and the Department of Justice now agree that the panel should reconsider its previous position, specifically the claim that suppressors are not protected arms, it's highly likely that this is exactly what the panel intends to do during the rehearing. Because the court has withdrawn its entire prior decision, the panel will need to revisit not only the question of whether suppressors fall under Second Amendment protection, but also all related issues, including the National Firearms Act's taxation and registration requirements. The Trump administration's DOJ continues to argue that the NFA process is constitutional, emphasizing that it does not amount to a total ban on suppressors. However, they will likely need to expand on that argument in greater detail in the upcoming briefs. If the panel requests an oral argument, the DOJ will also need to address these points in person, clarifying their stance and possibly presenting additional legal reasoning. This shift in the DOJ's position has had a significant impact on the case. It's rare to see the federal government reverse course mid-litigation, especially on a constitutional issue. But that's exactly what happened here, and it's brought new momentum to Peterson's challenge. Whether the Fifth Circuit ultimately agrees to rehear the case and what conclusion they reach remains to be seen. But one thing is already clear. Both the defendant and the government are now aligned in saying that suppressors should be considered protected arms under the Second Amendment. If the panel agrees, it could result in a major ruling. It would also create a direct conflict with decisions from other federal courts, such as the 10th Circuit and the 9th Circuit, which have held that suppressors are not protected by the Second Amendment. This potential circuit split is important. When federal courts disagree on a constitutional issue, it often sets the stage for the Supreme Court to step in and resolve the matter on a national level. So if the Fifth Circuit panel finds in favor of Peterson and recognizes suppressors as constitutionally protected, it would likely bring this issue to the forefront of future legal battles across the country. There's another layer to all of this as well. If Congress ends up passing the Hearing Protection Act, and it's signed into law by a future Trump administration, much of this legal debate could become irrelevant. The HPA would remove suppressors from the NFA's scope entirely, making them easier to own and eliminating many of the regulatory hurdles currently in place. That would be a massive win for gun rights advocates. If that happens, the larger constitutional question would lose some of its urgency. But for Peterson himself, the issue would still matter. His conviction occurred under the current law, and there would need to be a determination about whether that conviction should stand if the law changes. So that's the current situation in this critical case unfolding in the Fifth Circuit. As more updates come in, I'll be here to break them down. Thank you for watching. If you found this video helpful or informative, don't forget to like, leave a comment, and subscribe to stay updated on future developments.